Good morning. My name is Laurie Racca. I'm the Senior Registrar for Geology and Geophysics at the California Board for Professional Engineers, Land Surveyors, and Geologists. And that's a lot of fancy words that basically means I'm the staff geologist at the licensing board. Dallas, my counterpart.
Good morning. I'm the staff land surveyor for the board.
We're here to introduce you to concepts regarding professional licensing. We're going to go over several things today, mainly the basics. What is licensing and about the board? We're also hoping to address some of the common questions that we get about licensing. And at the end of the presentation, we're going to talk about several examples and open things up for question and discussion. So what exactly is a licensed professional? Most of you understand licensing because you drive a car. Licensing is the government's permission for you to do something. So just like with your driver's license, licensing involves certain qualification requirements to make sure that the professional doing the work is competent. And a professional is simply somebody who has been measured against a certain set of standards. In the case of professional licensing, it's the 3 E's: education, work experience, and passing the exams. The board is a group of 15 people, 8 of whom are public members and 7 of whom are practitioners. Most of them are appointed by the governor, with the exception of 2 public members, one appointed by the Senate Rules Committee and one by the Speaker of the Assembly. And the board's mission is protection of the public. So whenever you interact with the board, you need to keep that in mind. Every single law with regards to our professions, whether it's engineering, land surveying, or geology, has this exact same text within the statute itself. And it makes it very clear that our marching orders from the legislature are protection of the public is our primary concern. These are the authorizing statutes for the board's professions, and the board implements those via the regulations that have been developed through the public rulemaking process. One thing to keep in mind as you work with licensees is that there are many different types of licenses, especially for engineering. So with our disciplines, we have the engineers, land surveyors, and geologists, and these are the practice authority licenses. A practice authority license is simply something that says you can do this. This is the authority to practice the profession. And you'll notice for engineering there are 3 different practice authorities. For land surveying there's 1, and for geology and geophysics there are 2. There's also something called title authorities. These are the specialty licenses. For civil engineering, that's geotechnical engineering and or structural engineering. For geology, it's engineering geology or hydrogeology. So only a licensed geologist can use the title Certified Engineering Geologist. But these title authorities do not restrict the practice in any way. Any geologist can practice engineering geology or hydrogeology. They simply cannot use these titles. Same thing with the title authorities for the engineers. The engineers also have a 3rd category of license called Title Acts. And these are a little bit strange in that only the title is regulated. So for example, a professional engineer, a professional chemical engineer, is a protected title. However, the board cannot regulate the practice of chemical engineering. They can only grant the use of the title. So me, as somebody who's not competent to practice chemical engineering in any way, can do so all day long, and there's nothing the board can do about it because it is not a regulated practice. The only thing I can't do is call myself a professional chemical engineer. So when you're dealing with a professional engineer, any of these titles can use the terms or the letters PE, professional engineer. So you really need to understand what type of license your engineer has and what they are legally allowed to do. So when is a license required? Licensing is an individual authority. It's not granted to regulatory agencies. It's not granted to companies. It is granted to individuals. So whenever a person practices any of the protected professions, engineering, land surveying, or geology, they have to be licensed. And there are several common exemptions. There's the federal exemption. The state cannot impose licensing laws on the federal government. There are some exemptions for surveyors with that, if you want to go over that.
Yeah, so surveyors that are working for the federal government, they have their exemptions surveying on federal lands. There's also some exemptions working under certain agencies, like municipalities or utility companies that exceed a certain dollar amount of gross receipts a year. Those exemptions are all within the Land Surveyors Act at 8730 is where they're listed under there.
And then each of the acts has an exemption for subordinates. So as you're earning your work experience when you first get out of college, you can't legally practice on your own because you're not licensed. So it's kind of like your driver's permit when you first take your driver's ed class, and then you are allowed to drive as long as there's an adult who's licensed in the car. That's what the exemption for subordinates is. Basically, you are working, practicing your profession under somebody who is licensed and who's keeping an eye on what you're doing and approving or disapproving your work. There's a bunch of miscellaneous exemptions, and this list isn't all-inclusive. For example, a geologist can create a map as part of their work without violating the Surveying Act, but you need to understand the details of exactly what you're doing. A very common situation in geology is monitoring wells. People want to survey the tops of monitoring wells and claim they can do so under this geology exemption. Well, they can't, because the top of a monitoring well is a three-dimensional reference point in space. It's not a geologic feature. The geologic feature is the depth to water in that well. So you have to make sure you break down each task into its component parts in order to understand whether or not you fall within the exemption or whether or not you need a licensed person to do certain things. There's also the limited exemption to the Geologist and Geophysicist Act for civil and petroleum engineers. And you have to be careful with this one because a lot of engineers don't understand that exemption. They think that they can do anything that pertains to geology, when in reality a civil or petroleum engineer can only do geologic work directly related to and incidental to their practice of either civil engineering or petroleum engineering as defined in the law. So you have to look at the law and decide, okay, this is civil engineering, so therefore I can do this part of the work under that exemption. And as Dallas said, public utilities have certain exemptions, contractors have certain exemptions, and a really important one for surveying is the pre-82 civil exemption, which I'll let Dallas explain.
Right. So any civil engineer that was licensed prior to 1982 is able to do all aspects of land surveying, including boundary surveying. Any civil engineer licensed post-1982 is only allowed to do construction surveying and topographical surveying that does not bring into the geodetic surveying and the ellipsoid. So basically you can do surveying as long as you're not tying it into the California coordinate system if you're post-82, or using the ellipsoid and geodetic surveying as those exemptions.
The big take-home message is if you think you fall under an exemption, please contact us because we can help you work through that specific situation that you're dealing with and help you arrive at an answer that you can use. The other common exemption, I call it the mythical industrial exemption or the in-house exemption. And a lot of people get very confused about this, especially when it relates to mining or to oil and gas. In California, if you're doing geologic work internal to your company, you are exempt from the licensing laws. So for example, if you are doing exploratory work for oil and gas for Chevron, and the only people who use that data are people internal to Chevron, then you are exempt from the licensing laws. However, the minute you take that data and go over to the Division of Oil and Gas and apply for an injection well permit to get rid of wastewater, then that's public practice, and that data, that work has to be done under a licensee. So a lot of times people doing work on a mine just automatically assume that everything connected to that mine is exempt, and that's not necessarily the case. The other thing to keep in mind is that licensing does apply to all state, local entities as far as governments, the special districts, anything like that. All of those employees are required to be licensed in the discipline if they are making comments on the professional practice of others. So for example, when I worked for the Water Board or the Department of Toxic Substances Control, and I commented on a report that was submitted to me, and I made professional geologic judgments regarding another person's work, that is regulated practice. So just because you work for a government doesn't mean that you're exempt from the licensing laws. I've quoted a section of the regulations for geologists in this presentation. However, there are very similar requirements for both land surveyors and engineers.
And going back to what you'd previously said, Laurie, is we as a board, we license the individuals. We do not license the business, the agency,
right,
or the entity. It's the individuals we license, and so that's very important here, and as we previously said.
Well, and the corollary to that is that it's the individuals that get the unlicensed practice fine, or the individuals who get a complaint filed against their license. It's not the county of San Joaquin, it's the geologist or the engineer or the land surveyor who does work for the county of San Joaquin who gets the complaint filed against them. And if any of you, as anybody who works for government knows, unhappy people tend to take advantage of complaint processes, whether the complaint is valid or not. Responsible charge and agency licensees. The engineers and land surveyors have a requirement to file something called an organization record, and that's for private sector individuals. The corollary for that is that for government agencies, we've developed a special form so that county, state, any local government agency can help their licensees comply with the organization record requirement. And I'm going to let Dallas go into that.
And the NOD form also applies to special districts in addition to, because they are covered under the sections of both PLS and all three acts. So what the NOD form is, it's a form that we ask you to fill out that gives us the information of those that are in responsible charge. That would be your county engineer or your city engineer that's in responsible charge of all aspects of engineering. That would be the land surveyor that's in responsible charge of all aspects of land surveying. And what that's for is so we have somebody to contact. If something comes up, if there's an issue, if there's a complaint, or we just need information. This NOD form gives us the opportunity to know who to go to without having to search or go through many layers. We can go right to the person that we need to talk to and figure out what was wrong and what a potential solution could be. And the NOD form, as you see, there is a link here on the slides. And if you follow that link, the NOD form is there on our webpage, and it is a fillable PDF, and you can send it back to us as a PDF, and then we go ahead and save it in our system.
All of this information is available on our website, and you can feel free to email either myself or Dallas, and we'll send you a direct link to the information you need, because as with any government website, sometimes our internet site is a little bit difficult to navigate. This is what the NOD form looks like. And responsible charge is something that a lot of people don't understand. We throw that term around when we talk about who's agency licensees and the NOD form, but responsible charge means who is in charge of the technical work. You're either doing the work, you're either assigning and reviewing and approving the work, you're directing somebody how to do the work. Anything that you do that involves professional, independent interpretation or judgment could basically be responsible charge. Now, responsible charge doesn't include the concept of financial liability. It doesn't include anything to do with management hierarchy or any kind of administrative function. So, for example, my boss, the assistant executive officer of the board, isn't in responsible charge. She's not licensed. She's my boss. She signs my paycheck. She directs the tasks that I need to do. But anything that I do that requires professional geologic judgment, I'm the one who's in responsible charge, and that's indicated by my signature and seal. So even though you can call Nancy and complain about anything I do, she is not in technical responsible charge of my work. Responsible charge is defined very clearly in each of the 3 acts with engineering, land surveying, and geology. The board rules for engineers and land surveyors include some additional explanation of that. We're in the process of trying to get that additional explanation into the regulations for geology and geophysics. But as we said previously, it all has to do with the extent of control and who's making the decisions, who's reviewing and approving the work. Did you want to add anything about responsible charge?
It's covered.
Okay. And then a licensee is only entitled to be in responsible charge of work for which they are competent to do the work. And that concept is incorporated in both the board rules for engineers and land surveyors and the regulations relating to the practice of geology and geophysics. So what that means is, as a licensed geologist, I can do anything related to geology under my license, but only if I'm competent to do so. My entire career, or most of my career, has been spent in environmental cleanup and groundwater work. I've done a little bit of engineering geology work. Would I go out and do a fault trench these days? Probably not. It's probably been 25 years since I've done something like that, and I don't feel competent to do so. So if I was to engage in that type of work, I'd make sure that I was working with another licensee who was competent to do that work. So your license doesn't entitle you to do everything. It just entitles you to do the work for which you are competent. The other thing that comes into the concept of professional licensing is that a licensee has to abide by the laws and regulations that pertain to the practice of their profession. And important to that is the professional standards and codes of professional conduct. These things are similar to ethics. Ethics are voluntary standards. Codes of conduct are required standards. So, for example, the statement, "murder is morally wrong," is an ethical statement. Murder violates penal code blah, 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 and is subject to these penalties, is a measurable standard that is included in the law. So there are standards of conduct that are in each of the 3 acts and refer to additional details that are in each of the regulations. So that's one reason why it's really important to make sure that you're using a licensed professional whenever you need engineering, land surveying, or geology work. The other thing that a lot of people aren't aware of is that businesses offering any of these professions have certain requirements that they have to meet in their corporate structures. There are requirements that if you're going to offer to practice geology, you have to have a licensed professional in your business structure. And these requirements can get a little bit complicated and is beyond the scope of this presentation. But just keep in mind that if you're hiring somebody to do this type of work, you should contact the board and we'll walk you through how to evaluate whether or not the company you're hiring has the proper structure to be able to do that type of work. You want to add anything?
Well, it's important to check with us on that, because there are businesses out there that offer engineering services, they offer surveying services, geologic services, and they may not have one of the 3 licensees in their corporate structure, and therefore they're not authorized to practice, which is actually a violation under the acts.
So the biggest source of confusion people have is, which license do I need? And some of that is because they misinterpret the way both the board's laws and other laws are written. A very common example that you see in laws and regulations in California is this work requires a professional geologist, licensed civil engineer, landscape architect, or professional forester, all in the same sentence. And the tendency that most people have is to interpret this as these licenses are interchangeable, when in reality that law or regulation is actually saying that if you're doing geology work, you need a professional geologist. If you're doing forestry work, you need a professional forester. It doesn't mean that those licenses are interchangeable. And then sometimes people misunderstand the definitions. There's a quote on the screen from a particular regulation administered by a state agency that references a certification signed by an independent qualified professional engineer. And if you look back to the slide that talks about the different types of licenses, you'll remember that almost any different license type, whether it's a practice authority, a title authority, or a title act, any of those engineers can call themselves a professional engineer. So what did this agency mean? One would hope that they're using that in the context of if you need an electrical engineer, you're going to get a professional electrical engineer. But it shouldn't be interpreted to mean that any professional engineer, whether it's an agricultural engineer or a traffic engineer, can do the type of engineering that you need. You have to understand that there are specific definitions in the law about the various license types. Another source of confusion is other agency laws and regulations that people interpret as modifying or amending the licensing laws when they don't. A very common one is the Water Board's stormwater certifications. The QSD and QSP certifications do not allow the holder to practice engineering, land surveying, or geology, and very often people with those certifications wind up running afoul of the law because they do some kind of drainage work or they do some kind of engineering calculation that requires a civil engineer. And then they get upset and feel betrayed when they find out that they're actually in violation of the law because they've got this certification from another agency that they interpreted to mean that they could do that type of work. Another area where people tend to think is exempt from licensing laws is Sequa. So if you're going through the Sequa process and you are preparing an initial study or some other kind of environmental document, if part of that work involves engineering, land surveying, or geology, that portion of the work has to be done under an appropriately licensed professional. Sequa does not provide an exemption for that work. If you're doing an environmental impact report and there's consultant reports in the appendix, yes, you can summarize their reports in the text as long as you're referring back to the work done by the licensee and it's very clear which licensee did that work. But just because it's a Sequa document doesn't make it exempt from the licensing laws. So we wanted to discuss a few common examples and questions we normally get at a lot of these workshops. And a lot of them have to do with surveying, so I'm going to let Dallas start with the always popular GIS portal to establish a property boundary.
So when you're using a GIS portal, typically within the GIS portal you're getting a complete package. So what I mean by that is you go to a county's GIS and you put in the information and you pull up the parcel. You're going to see all the layers are there as one layer, meaning if there's roads, streams, boundary, features, topographical information is all there as one complete unit, and you were to take and do a screenshot of that and print that out, that is allowable because that is one complete unit, one complete package that you're using. Now, if you were to take that information and start to separate it and use the different layers independently and start referencing those layers independently on your submittals, now you're starting to encroach in the area of land surveying, and you'd need to have a licensed land surveyor to assist with that. Some areas that would typically happen is if you take a GIS-based map and say you go out to a site, and at that site you now measure from a fixed object. A fixed object is clearly defined in the Engineers Act. That is something that engineering was used to build, to develop. So say there's a building out there on the property and you want to reference that building, or a scale station, the house that the scales are in, and you want to reference that building to the property line. That is land surveying. You cannot do that without being a licensed land surveyor. Or if there's a fire hydrant or things like that, any fixed object, and you start referencing that to that property line that's shown on that GIS that you printed out, you're surveying. Just to use that GIS as a reference tool, you're fine. Or you can use the GIS to establish you can draw on the GIS drawing that you've printed out to show the areas of disturbance, as long as you are not measuring those areas of disturbance and showing a distance from the areas of disturbance to the boundary line, or you are not drawing on that GIS, say, the setbacks on the property. So you need to be very careful on what you're doing with that you're not referencing the fixed works or the areas of disturbance to the boundary line. The other one would be topography prepared from an aerial photo. Now there's a couple ways you can have that topography prepared. You can have it traditionally flown, but commonly today everyone is using drones and UAVs and UASs. That topography that you're preparing from an aerial photo is land surveying as defined in the Act. So to fly a site with a drone just to get pictures that you're going to use for informational purposes, that's fine. But if you're using those pictures and having those pictures ortho-rectified and creating topography with those pictures, then you're land surveying, and that needs to be done by a licensed land surveyor. So those are some areas that would be considered surveying. If you're ever doing a project and you're unsure if you're encroaching in surveying, please call or email me, and I'll gladly answer your questions and help you, because I'd rather talk to you on the front side than having an enforcement case in front of me where I have to talk to you on an enforcement side.
Yeah, well, we've got a list of questions here, and I think you just took care of the first one. Who can I contact to make sure that I am not performing work that I'm not licensed to undertake? And that's pretty easy. Just contact the board. You can call our main number, and there are 4 on-staff professionals, 2 engineers, a land surveyor, and a geologist. Just ask for the land surveyor. Dallas is the only one there. He's the one you're going to get. Or you can find our names, emails, and phone numbers on our website. Let's see. Would you need a licensed surveyor for staking a mineral claim on federal land?
Well, now that question is an interesting question because of the way it's worded. If you are an employee of the federal government, then no, you would not need to be a licensed surveyor in order to stake that claim. Now, if you're a private individual going out there, or say you're working for a company that's going to go in and develop that claim, and you're staking that ground, then yes, you would need to be licensed. So it all depends on who you were working for. If you're working for the federal government, you can stake that claim under the exemption for the federal government. If you're working for a private company that has rights to that claim, that's going to develop it, you need to be a licensed land surveyor.
Okay. Does an assessor's parcel map included as a plate in a reclamation plan map meet the requirement of a clearly defined and accurately drawn property line?
An assessor's map is actually, if you look at most assessor's maps, you'll see a disclaimer on them. And that disclaimer typically says something to the effect of, this map is not for boundary purposes, it is for assessment purposes only. By seeing that disclaimer on that map that's prepared by the assessor's office, I would not recommend using an assessor's map for any type of boundary reference whatsoever, because, like I said, they're for assessment purposes only, and quite often they could be incorrect.
All right. What if the assessor's parcel map was overlain on a reclamation plan map to identify property lines or setbacks? Does interpolation of the property lines from the APN map constitute the practice of land surveying? And if so, what do I do?
So the way this question is worded is as an individual, you're taking a component, putting that component onto another map, and making a judgment as to how those two maps would fit together. That would be considered mapping, and therefore that would be considered surveying. What I would recommend is looking at the county's GIS portal, because I think most counties in the state of California have a GIS portal that you could actually pull up and find a map that already has the layers that are established that you can use as a complete package to do that.
Okay. Does extracting a property boundary layer from a county GIS web service and then using the layer on a reclamation plan map constitute an accurately drawn property line?
So I touched on this when I was talking about the GIS portal in the first example. Again, you never want to separate those layers on the county GIS, because you start separating those layers, you're making a judgment, and now you're doing land surveying as it's defined in our act. Also, most all of those GIS layers, those GIS plats, assessor's maps, all have disclaimers because the accuracy is not there. So anytime you're using a GIS layer, or a GIS map, that is really reference only, because a lot of times those are items that are put together by the county and you're not getting the best representation of the property line. My recommendation would be, if you're ever in a situation at a site where you feel, just by being out there walking around, that potentially the area of disturbance or the planned area of disturbance is getting close to a property line, is to hire an appropriate licensed individual and have them come out and establish that boundary on the ground. And then they could also draw you a site map that shows where those features are, where that property line is, and they can stake out that property line and even stake out the setback for you, so there would be no further questions later on.
Well, I think you just answered the next question, which says, does delineating a reclamation plan boundary require a land surveyor?
Yes, I did answer that, and so yes, it does require a. Well, now let's clarify something on that. So a reclamation plan boundary, if that is just the boundary of the area to be reclaimed or the soil that's going to be disturbed, and it's clearly within the site, you would not need a surveyor to delineate the areas of disturbance. But if you're going to define the property lines that define property ownership, you would need a land surveyor. So that's a big difference in the two. Reclamation plan boundary is the area that would be disturbed. Property lines, or those ownership differences, that you need a surveyor for.
Which brings us very nicely into the next question, which is, can an inspector measure and record distances from a structure or facility to property boundaries if the property corners were previously marked by a land surveyor? So can you take distances from the property line or from the property corner established by a land surveyor?
So if you're just going to do some measurements out on the ground to see where things are from a previously established boundary, yes, you'd be fine with that. But if you start mapping that and showing it on a map that is going to be used to turn in a plan to an agency, to provide to the neighbors, to provide to anybody outside the company or agency you're working for, that would require a land surveyor. But if it's just for internal purposes only and never going to go outside, you'd be okay making those distances and measuring that off of something that a surveyor did.
Okay. That seems to be most of the surveying questions from the list. One thing that we often run into with reclamation plans are grading and drainage issues, and a lot of times we'll have a geologist signing and sealing a grading plan, which is the practice of civil engineering. So keep in mind that a lot of the grading and drainage work that is done as part of a reclamation plan may require a licensed civil engineer. So you should always check with us regarding the specifics of your individual situation if you aren't sure. Slope stability calculations are an area where there's overlap between geology and civil engineering. If the slope stability calculation involves a civil engineering fixed work, it's clearly the practice of civil engineering. If there is no civil engineering fixed work as designed in the law, then it can be a geologist who does that. So you need to truly understand the situation that you're dealing with. And if you're not sure, call us and we'll walk you through it and help you break it down into its component parts so you can understand what parts of the work can be done by an engineer and what parts of the work can be done by a geologist. Things like groundwater recharge and water supplies, these issues you might be addressing in a Sequa document. That type of work has to be done by a geologist. And in many cases, when you're evaluating watershed impacts, that work would also fall under the practice of geology. But again, the key thing is to understand that there is no global list of tasks in the law or the regulations that say, this is what a civil engineer can do, this is what a geologist can do, this is what a land surveyor could do. If we tried to do that, the law and regulations would be taller than the building I work in, and we'd be constantly revising them because new situations come up. So the best way to understand the licensing laws is, again, to break everything down into its component parts and understand the definitions of these practices in the law. And you don't have to do that by yourself. That's what we're here for.
And another aspect of that is we don't license equipment. We don't regulate equipment. We license the individual and the actions that the individual does with that equipment.
Right.
So that's always important to remember.
Yeah, that comes up a lot with surveying or geophysics. A lot of times people will want to use a ground penetrating radar unit to find something in the ground, and they think because this technology has a pretty screen with a bunch of little squiggles on it that they don't need to be licensed because the computer's doing everything. And that's not necessarily true. And I would imagine that comes into play with surveying a lot.
Yes, it
because
does.
with a lot of the total station equipment and such, or
Well, you could actually perform aspects of surveying with a hand level and a tape measure.
yeah,
So it's just what you're doing.
it's what you're doing, and knowing when the equipment is giving you a correct answer or an incorrect answer or something you need to look into further. Another question we have is regarding the Notice of Department Designation form. If the lead agency has a civil engineer and or a land surveyor identified as the individual in responsible charge on the NOD form, can the lead agency inspector act as a subordinate by taking measurements, observing ground surfaces, and recording site conditions? What are the limitations? Well, if you're going to be doing work underneath somebody else's license, you need to talk to them about what the limitations are, because they're in responsible charge. They're the one who from a legal standpoint is responsible for that technical work. So the general answer would be yes, if you're working under a licensee, you can do work, but you need to be understanding what that licensee feels comfortable with you doing, because it's their license on the line. Anything to add to that?
No, you covered that just.
All right, should reclamation plans, financial assurance cost estimates, and inspection reports be reviewed by my lead agency NOD person for civil engineering and or land surveying, even though the project is managed through the planning department? Well, if the document involves the practice of engineering, the practice of land surveying, or the practice of geology, a licensee has to be in responsible charge of that work. So if you don't have an engineer in the planning department that's working with you on the engineering aspects of a reclamation plan, then if somebody complains, we're going to go to the NOD form and we're going to see who's listed as the responsible charge engineer for your county, and we're going to ask them about it. And if they haven't heard of the project, there's probably going to be a problem. Right. So if you don't have an engineer, geologist, land surveyor within your county planning department, then you need to find out who's going to be acting as your responsible charge licensee. So a few things to remember. As we keep repeating, the board licenses individuals, not companies, not agencies. The license laws do apply to state, local government employees, special districts, but they do not apply to the federal government. Businesses offering engineering, land surveying, or geology, geophysics must meet certain requirements, and the board exists to protect the public. We are not here to represent the licensees. So if you have any questions for the board, keep in mind that the answer is going to be, we're here to protect the public, and if we feel that a particular aspect of that situation doesn't protect the public, we're going to do what we can to address that. Here's our contact information. Rick Moore is our executive officer. I'm the staff geologist. Dallas is the staff land surveyor. I don't have the two engineers up here right now, but just call the office and ask for one of the engineers and they'll be happy to help you. We have an entire enforcement staff whose job is to answer questions about the laws and regulations. A lot of people feel uncomfortable because the word enforcement is in there, but these people work with the lawyers on a daily basis and are the ones who can give you the most up-to-date and correct interpretation of the law and regulations. They're there to help you. They're not there to get you in trouble. So please feel comfortable with that. And if you do want to file a complaint or have questions about filing a complaint, please visit our website or call our office. There's a video online how to file a complaint. Or if you're not sure if something merits a complaint, you can always just call and talk to us. So anything in closing?
No, I think we covered everything.
I Thank you very much for your attention. If you have any questions, please give us a call. Thank you.
Thank you.